It's only just 11 o'clock, so we'll give it a moment or two for everybody else to join. We've got quite a big crowd today. And there's a fire alarm that's just gone off in the background. Hopefully, you won't be able to hear that. It's only for my ears, but all over. So good timing. So we'll give it a minute or two and then we'll start the session. There's a lot to go through today. Still a few people joining. I can see the numbers creeping up, so we'll just wait for a moment. Thank you for your patience. Okay, I think it's time we can begin. So let's start. Um, Thank you for everybody for joining us for this update on key changes to employment law. My name is Sarah Gray, and I'll be your host today. I'm joined by my colleague Lily Evans, who will take note of any questions that you have, and we can address those hopefully at the end. So please jot your questions down in the chat area. And if we don't have enough chance to go through them, fear not, we will send out a Q&A sheet along with a link to this recording after the presentation, so you've got that to refer to. So let's get started. It's been a busy time in employment rights HR world. The Employment Rights Bill, all 310 pages of it, represents one of the most significant overhauls of employment legislation in recent history. Understandably, it's causing considerable uncertainty amongst employers as they try to navigate the coming changes. So, where do things currently stand? The bill has passed through the House of Commons, where its wording has been looked at, amended, and debated. It's now with the House of Lords. And whilst the Lords can propose further changes, they can't remove any provisions outright. And the Commons is not obliged to adopt their recommendations. So this means that we now have a much clearer picture of what the final version of the bill is likely to look like. There are still many public consultations and a myriad of statutory instruments that need to be prepared. And of course, these are the things that will contain much of the detail that we need to inform us about what we need to do. This means that many parts of the Employment Rights Bill, or as we presume it's going to be called, the Employment Rights Act 2025, um, we're presuming that won't come into force for a little while yet. We know a lot of the content won't come into force, as I said, until 2026 at the earliest, because the government have already said that. But some of it will come into force this autumn. And what we will do is start by giving you the predictions as to what these issues will be and some tips to help you prepare. And then we'll do the same as to what will come into force next year and then later in 2027. So that's what you'll walk away with today. We expect the things on this slide to come into effect pretty much immediately. And by that, we mean around October. So things like the prohibition on dismissing anyone who refuses changes to their terms and conditions of employment, the change to how long an employee has to bring a claim to the Employment Tribunal, repeals to some of the trade union laws, a change to the flexible working provisions, And the last one here, the categorisation of complaints of sexual harassment qualifying as a disclosure for whistleblowing purposes. And to be honest, that's a bit of window dressing, as it's hard to think of why a sexual harassment complaint wouldn't already qualify for this. So let's revisit these in more detail. Fire and rehire. This is one of the areas that is likely to come into effect as soon as the bill receives royal assent. For those of you who are interested, it is found at clause 26 of the Employment Rights Bill if you want to do some bedtime reading. The key purpose of this is to outlaw the practice that's known as fire and rehire by preventing employers from forcing through contract changes under the threat of dismissal. If an employer was to unilaterally impose changes by dismissing and offering a rehire on new terms, it would automatically be deemed as unfair dismissal. So, this covers things like dismissing an employee and rehiring them on a reduced wage, dismissing an employee and rehiring somebody else to do substantially the same job but on different terms and conditions, where an employer seeks to make any contractual variations and the employee does not agree and the employer dismisses them as a result. So, an example of this may be that the employer wants to withdraw a benefit, say a benefit of health insurance, which is part of their, forms part of their contract of employment, and the employee doesn't want to agree to that. If they were to be dismissed on the basis of that, it would automatically be unfair dismissal. And that's probably not too surprising. But what if the employer wants to amend a contractual commission or bonus scheme and the employee doesn't agree? Basically, it's the same. If dismissed for not agreeing and it's part of the contractual terms, then it will automatically be an unfair dismissal. So, what this means in practice is that the employee will not feel compelled to agree to any contractual variations and will be protected if they refuse. If an employee has a contractual shift pattern and the employer needs to change it, but the employee refuses, the employer cannot dismiss an offer to re engage or dismiss and hire somebody else. So it might seem that the employer's only option here is to dismiss and not replace the individual and then fight the ensuing unfair dismissal claim, arguing that potentially that would have been a redundancy. But that's not a good solution because then the employer doesn't have anyone to do the job, which is probably worse than having someone who doesn't want to work the actual or ideal hours. So we have a situation because because of this, the absolute ban on dismissing for refusing any contract variation, that the cure may be worse than the actual disease. And that is that this change is going to push employers into bankruptcy because they can't engage, fire, and rehire when they really need to. So the bill includes a very limited exception where the employer can prove the dismissal was a truly last resort absolute necessity due to serious and imminent financial difficulties threatening the viability of the business. So that's the only exception. So think about a large cleaning company as an example. They send a team of cleaners to a business client of theirs between the hours of 6 p.m. and 10 p.m. The client then says they're needing to change their operations. It doesn't suit them anymore, and they want to change the times of cleaning from 11 p.m. to 2 a.m. or from midnight to 6 a.m. So, how does the cleaning company change the contractual shift patterns? Given they're a large company with potentially a large number of clients, it's not likely that they could use the exception of facing financial collapse and dismiss the cleaners if they refuse to change the work patterns. So they would need to be creative in juggling around shift patterns and perhaps looking for different kinds of incentives to make it worthwhile for people to take different shifts. One piece of good news is that the government was originally thinking about bringing in the right to claim interim relief for dismissals arising from a refusal to accept changes to contractual terms. Interim relief is a very powerful remedy where the employee can get an injunction compelling the employer to continue to pay their salary until the tribunal hearing. We all know what kind of delay there is on those. At the moment, it's only available for whistleblowing and certain trade union related dismissals. However, as I said, it was good news. The government has now said categorically that it's not going to bring in interim relief for fire and rehire dismissals. So, something positive. Are there any workarounds? One way may be to introduce a greater reliance on contractual variation clauses. So, ostensibly, this means allowing certain changes to terms without additional consent being required. We've seen some case law already that upholds this right to vary terms where there is a very well drafted and unambiguous variation clause even where that change imposed disadvantaged the employee. So that's interesting. I think it was a case with ASDA, if I'm not mistaken. However, having said that, employers would need to exercise such clauses with caution. It can be seen that these variation clauses might be unreasonable, and I'm not sure that the Employment Tribunal would look very kindly on you, and it's likely that a case could be made for constructive dismissal. And of course, we haven't seen this in the final legislation yet. So there may be safety provision in there for employees against employees using contract variation clauses, but we'll definitely keep you posted. It's one that is highly important. The second option may be to dismiss the staff and replace them with agency workers. And as it stands, if the agency workers are not employed directly by the company, it technically falls outside of the ban of firing and rehiring someone. But A, it probably costs a lot more, and B, there's every chance that it could be a choopy situation if the agency employs the same staff that you've dismissed. And it's unlikely that any agency would want to touch that with a barge pole anyway, so probably one to avoid. The lesson is that there is no big stick anymore. So employees who do not want to accept different terms under their contract will be able to refuse from a much stronger position. So one to watch. Looking at this issue from an HR perspective, here are some things that you may want to consider if the situation impacts on you. Consult and communicate. Explain the business rationale if you have to make some changes. Encourage employee feedback and give them an option to provide alternative proposals. Sorry, Tommy, I've just seen you saying, when does the 2025 Act come into place? I'm taking you through all of these. The ones I'm talking about at the moment are likely to come into place around October, and then you'll see from the slide deck when the others will come into place. So as I said, we're looking to communicate as clearly as we possibly can to maybe give them some alternatives and get their buy-in. And from an HR perspective, it's always best to plan for any changes well ahead of time so you can introduce those changes gradually. We all know nobody likes huge amounts of change dumped on them. Whatever means you can to communicate clearly to all impacted employees and be as open as you can. So, don't just send out emails, have meetings and town halls or whatever it is you do in your business to try and communicate those things. And if the change involves a move to something like new technology or a different structure, it might be consider it might be worthwhile considering investing in upskilling staff to help them prepare and alleviate their concerns. Try to show that the burden of change is being shared. So, if this is about cost cutting, it shouldn't only be those lower paid employees who are disadvantaged. So, what sacrifices a senior employee is going to make, or what it is perceived that they're going to make. And I'll give you an example. I worked in a business a little while ago where they were talking about austerity and everybody had to batten down the hatches. And the next thing we knew, there were all these wonderful new bright shiny BMWs in the staff car park that were given to senior execs. So it was a really distorted message. Yes, we all have to we batten down the hatches and tighten our belts, but not so much for the senior executives. So be aware of what the company is doing and how that's looking. Recognize that not every employee's situation is the same either. So some people might easily adapt to a contract change, particularly if it's a a change in shift pattern. It might not concern them. But if you're a single parent, juggling a new shift pattern could be quite burdensome. So where there's a proposed variation for an individual, try and look at whether those things can be accommodated. Also, negotiate the new terms. Is there something you can offer in return that has a value to them that might not necessarily be monetary? So it could be a one-off bonus or an improved benefit to offset a reduction. Perhaps an extra day of annual leave might be appropriate to get these things over the line and get agreement. You could use existing variation clauses, as I've spoken about variation clauses a moment ago, but only if the terms exist and it's worded very carefully. And if you are going to do this, please still ensure that the changes are fair and reasonable and necessary. You can't just have a blanket variation clause in there and get away with murder. So, if you're relying on the exception rule to demonstrate financial hardship to the business, then you have to make sure that you can absolutely document and demonstrate that. It will be something that comes under scrutiny. Time limits. So, this is another proposed change for 2025. And it's one that we think is going to come in quite quickly. Section 149 of the Employment Rights Bill is relatively nice and simple. It says increase in time limits for making claims. Schedule 12 makes amendments for the purpose of increasing time limits for making claims in employment tribunals in Great Britain and in certain cases industrial tribunals in Northern Ireland from 3 months to 6 months. Simple and clear? Yes, except for one thing. It doesn't include the Employment Tribunal's extension of jurisdiction for England and Wales Order 1994, which happens to cover claims for breach of contract after employment rights have finished. So the question is, does that mean that the time limit for contract claims might be going to remain at 3 months? The lawyers that I've spoken to on this believe that it's actually an accidental omission and that it will be corrected in a statutory instrument later, as it's not something that needs a separate act of Parliament to change. So I think we can accept that employees will have 6 months to raise a claim in the future. And we presume that this change is likely to lead to more claims. The more positive aspect is that it also allows more time to seek resolution and solve the issue through an internal grievance or appeals process without the need to rush to get a tribunal claim in. But it may also mean that many employees bring a claim because they have extra time, and we anticipate potentially more, not less, being raised. So, some of the things that you can do now, importantly, is to ensure that you have the ability to document everything and keep it for sufficient time to defend yourself in the case of a claim. So, when things go a little awry, document everything and reassess your internal processes for handling disputes. So, that's your policy and that's your procedures. Make sure that your internal grievance, your disciplinary and appeals processes give employees the right time and the time to raise issues internally before resorting to a tribunal claim. And one of the key questions to ask yourself is, are your managers trained up to deal effectively with issues as they arise? If you're a client of our Centra HR outsourcing, you will know that your line managers can get early and comprehensive step by step support right from the very first sign of an issue arising. And as you all probably already know, early intervention is the best solution for any HR issue. So as soon as something looks like it might be going wrong, if you're one of our clients, please call us and we'll talk you through all the steps you need to consider. This change relates to trade unions. So the change is particularly around reducing the current laws that make it difficult to strike. And there's a bit of conflict for the government here. No one wants to see more strikes. I mean, think Birmingham Council and the mountains of rubbish that are appearing and needing to be collected. But the reality is that large elements of the Labor Party are trade unions. So we think this will be one that comes in quickly. It doesn't need any further consultation, so it's an easy win from their perspective. The best advice, of course, is to make friends and keep close to your union and encourage clear communication. Think about what strike action you may be open to, and wherever you can, develop contingency plans and strategies to prepare for any potential disruptions. Some of the other key changes being proposed around trade unions, if you're a union site, are these. The notice period for industrial action will increase from 7 to 10 days. The permission for trade unions to have virtual access to workplaces will be made. Unions will no longer need to ballot members every 10 years to maintain a political fund. Instead, there will be a requirement to give members notice of their right to opt out. Introduction of e-balloting and workplace balloting for trade union votes, and enhancing the protections for trade union representatives and members through secondary legislation. Moving to flexible working. There is already provision for an employee to request flexible working as a day one employment right. So this isn't anything new. And as we all know, this was previously only granted to employees who had 26 weeks of continuous employment. So it's been a substantial change. As it stands now, employers have 2 months to respond to requests and must consult with the employee making the request before they can refuse it. And there are quite specific grounds for refusal. So those things are burden of cost, detrimental impact on ability to meet client demands, inability to reorganise work amongst existing staff, or it might be the inability to recruit additional staff. The Employment Rights Bill looks to strengthen this framework even further. And they look at that by ensuring employers do not refuse a request unless it is reasonable to do so. So there's a stronger onus of responsibility. Making employers provide detailed justification for why they refuse the request, and imposing consultation requirements that an employer must take before refusing a request for flexible working. So it's a bit of a strengthening and enhancing of something that already exists. Some of the things that you might be able to start to do now is to review and consider what you would like in your flexible working policy and ensure that you have a process that conforms with the requirements of the bill. Provide training and direction to line managers so that once the changes are known, it helps prepare them for that. And also think about your workplace culture. Do you genuinely support flexibility and work life balance, or do you need to make some adjustments? Now, that's it for this year, which is pretty much quite a reasonable amount. So let's move on to 2026, which scarily is not that far away when it comes to planning. We all know that once we've seen the exit of Easter eggs, it won't be long before we see Christmas decorations in the shops. So it's not far off. Always comes around faster than you anticipate. So this is a list of what we're told will come through next year. And I'll talk you through each of these changes. Unfair dismissal changes, statutory sick pay, third party sexual harassment liability, a range of family friendly changes, changes to triggers for collective redundancy, and last but not least, something around equality action plans as well. So a nice little bundle of things for us to look forward to. Day one, unfair dismissal rights. And this is the big one. And it's set to be one of the most impactful changes of all of the government's reforms, in my opinion. The proposal removes the current 2-year qualifying period for unfair dismissal rights, meaning that employees will have the right to claim for unfair dismissal right from the start of their employment relationship. So, this means potentially an increased risk of litigation of new hires. Employers will need to be much more careful during probationary periods. Greater focus on documentation regarding performance, behaviour, and decision making from day one. And a lot more attention and care in the recruitment of new employees and workers. Now we know this is going to happen. So my advice is don't sit around idly waiting for these changes. Let's start working on your businesses to overcome these now and embed them so that you're well and truly prepared. So these are the things that I would suggest that you do. Assess your recruitment practices. And when we think about that, think about the interviewing and assessment skills of your line managers. Don't rely on standard questions in interviews alone. Think about scenario based questions and assessments wherever you can. And if you need help with this, please let us know. We can certainly give you some assistance. We all know now that we're seeing more of an abundance of CVs that are generated by AI. Employees are also quite adept at potential candidates, I should say, are quite adept at bending the truth a little bit. So assessments is a much better way of assessing whether they really do know their stuff. Scenarios in an interview. Look at the metrics that you have in your business and see what you can gain from those. So, how many of your employees need extension to probations, for instance? Is that something that happens a lot or very rarely? And if it does, is this a symptom of poor recruitment practice or is your induction failing? And if so, where and how? And what can you do to improve the monitoring and evaluation of a new recruit during their probation? Again, if you don't have a structured and well communicated probation review process, please let us know because we can certainly help you with that. We've got some excellent tools. Changes to unfair dismissals will definitely mean that managing probation will be even more crucial than it is currently. On the issue of probation, we're expecting some changes to the time frame for the duration of probation. So the Employment Rights Bill suggests capping probation at 9 months, including any extensions. And as you know, there is currently no legal maximum for probation periods in the UK, and typically these are set for generally 3 or 6 months. And of course, this will necessitate changes to policies. Again, where you're a central HR outsourcing client, you will have all the policy updates provided to you as and when these changes occur. It's also advisable to make sure that you start preparing your managers to be more comfortable to go through how they should handle, how they can handle conversations around performance. For new line managers, particularly, this can be quite an anxious time and something that they're not prepared or really proficient at. Statutory sick pay from day one. The big change around statutory sick pay is the removal of the 3-day waiting period. At the moment, employers can only get SSP from day 4 of being unwell. But the change in the Employment Rights Bill that we expect to come through next year will allow employees to be entitled for this payment from their first day of sickness absence. In addition, there will no longer be a lower earning threshold to qualify for statutory sick pay. At the moment, if employees are not earning, I think it's £125 per week, they're not entitled to claim for statutory sick pay. The Employment Rights Bill removes this rule, making statutory sick pay effective at the rate of about 80% of their normal weekly earnings with a cap of what used to be called the flat rate, which I think is £118.75 per week. So for those doing one shift on a minimum wage, they would get 80% of their normal pay as SSP. But for those who are on more, I think it's around 6,500 per annum, which is most people, they'll only get the £118.75 per week. So what does this mean? On the negative side, an employee who does not get company sick pay and pulls a sickie for a day off will get paid. So this could have the potential to increase the number of days of absence that you might see. So here are some tips on how you can start to prepare for this one. If you offer enhanced sick pay, which aligns with statutory sick pay, that is, it also becomes payable from day 4, consider changing that to maintain the status quo. In other words, change your contractual scheme so it no longer aligns exactly with the statutory sick pay regime. They only get statutory sick pay from days 1 to 3, and company sick pay might kick in on day 4. If you're going to do this, and it will mean a change to terms and conditions, make sure you do it before the new act comes into force. Review your sickness policy. And again, if you're not with Centra, um, you'll have to do that yourself. If you're with us, we'll do that for you. This should have strict protocols around how and when somebody needs to advise you of their absence. And my suggestion is always to not let this be anything other than a direct call from the employee to their line manager. No texting, no emailing, make it a call. The more difficult it is, the more unlikely somebody is just to take the day off. So don't make it easy for people not to come in. Think about monitoring employees have a pattern of absence too. So we often see, the same people taking Mondays and Fridays off typically, or it might be a particular day in the month. If this is something that's occurring in your workplace, you may need to look at what triggers you bring in to prompt a meeting to discuss attendance. So sometimes it's not good enough to say it's 20 days or over, or it's on 3 or more occasions. Think about what that might look like and what works for you in your business and your operation. Also, make sure that you have a consistently applied return to work interview process. And I can't sort of advocate for this more strongly. You don't want to make it easy for malingerers to get away with absence and not have to face any conversation or a discussion about why they were off sick. So make sure that that's consistently applied, that all your managers know to do that and how to do it. And very importantly, jump on repeated absence early and ensure that you have capability procedures in place. And please, where it's relevant, use occupational health assessments. It's amazing to us how many new clients we get come on board who have got long term absence in train, and they haven't started to even use occupational health yet. So please consider that where you need to. Employer liability for third party sexual harassment. So, the law recently changed on this, meaning that all employers now have an active legal requirement to take steps to anticipate and ward off sexual harassment in the workplace so far as is reasonable. The Equality and Human Rights Commission suggests that the best way of assessing risk is to undertake an assessment of the risk factors in your business. And if you haven't already done this, please talk to us about our sexual harassment audit, where we can evaluate the risk from within your business. And we also include a third party risk assessment as part of that audit process. We know that many employers are relying on an e learning module to employees to demonstrate that they have taken effective and sufficient measures. But please be aware this will not be deemed to be enough if you need to defend a claim. Anti-harassment and anti-sexual harassment policies should be updated, and train your managers to identify risk, to manage it, and most importantly, to respond to it in a way that is appropriate and won't lead to a claim that's uplifted by a further 25%. Of the significant claims that we've seen go through the tribunal so far, A lot have been because the line manager has made comments that are inappropriate. Things like, "Oh, you should be complimented by the fact that people have made those comments about you. Don't take offence. What's wrong with you? Just move on." It's those sorts of things from line managers, potentially meaning well, but obviously not fulfilling their obligation, and certainly resulting in a huge financial impediment. And when I say huge financial impediments, we're talking many thousands of pounds, tens of thousands of pounds. It's also looking like the provision will be extended to any form of harassment, so by third parties, not just sexual harassment. And important to remember that third parties include your clients, your customers, contractors, freelancers, and suppliers. So review your contracts with suppliers and ensure that you have an anti harassment clause drafted and inserted into those contracts. And if you haven't got one, please talk to us and we can provide you with one if you need it. And importantly, think about setting parameters and safeguards. So if you have employees who attend social or external events, and when you invite others into your premises, think about it. No one wants to be a wowser. Actually, is wowser an English term, Lily? No. No one wants to be a killjoy. Sorry, that's a little Australianism that's thrown in there. But please think about any event, particularly where there is alcohol thrown into the mix, like end of year celebrations. There are often accidents waiting to happen. Day one rights for parental and paternity leave. Currently, parental leave requires 1 year of continuous service, and paternity leave requires 26 weeks. Whilst ordinary parental leave is unpaid, think about the impediment that this would bring to your business if your new recruit wants to exercise their right not to attend work for up to 4 weeks in any year for each child under the age of 18. So if you've got somebody with a large family, that can be considerable amount of time off. Um, and especially given that they retain all their employment rights in this period of leave. And employers can't refuse ordinary parental leave, they can only postpone it. So you have to have solid reason for this, of course, as well. Think about what you may need to do to develop contingency plans. So, for example, is there a benefit in cross training or encouraging workforce flexibility if you think you have a vulnerability in this area? Think about the reasons why you may need to postpone parental leave and how you might be able to justify this. So, what you need to collate in order to be able to do that. Review your workforce and consider whether you need to develop contingency plans to accommodate for the time you may lose. So, if you've got a couple of teams doing the same thing, but one of those teams is heavily weighted with team members who have families and the other one doesn't, it might be worth mixing those up so that you've got an even spread across the teams just in case. Enhanced bereavement leave. There are currently provisions for parents who lose a child or where they experience a stillbirth. This right is likely to be extended to a broader group of employees, covering additional relationships beyond immediate parent child connections. Specifics of the types of relationships, though, are still to be defined. We'll keep you posted. Providing enhanced protections for mothers who return from maternity leave is another one of these. So, giving returning mothers the right to go to the front of the queue for suitable alternative employment when redundancy occurs throughout the pregnancy or after returning from other various family leave. So, those are a few of the family friendly changes that we're anticipating in 2026. Collective redundancies. So, the widening of the test for when collective redundancy consultation is triggered. The government is keeping the one establishment test, but it has said that it will be adding other triggers. So, a potential example is if the employer is considering dismissing more than 10% of their workforce by way of redundancy, this may be one such trigger. We're still waiting on confirmations, and when they come through, we'll probably schedule a webinar specifically around these provisions and redundancy because it's quite a tricky one. There is also likely to be a doubling of the protective award for failing to consult properly, so from 90 days to 180 days. So currently, 90 days gross pay per employee, and that could be 180 days of gross pay per employee. So that's quite a hike if you don't do things correctly. The other change in 2026 is possibly around equality action plans. So the bill introduces a power requiring employers of 250 employees or more to publish action plans in relation to gender equality. And there's currently a consultation paper out on this now with a closing date of the 10th of June. So we'll see what comes out of that and how fast they move to implement. It could be earlier than 2026, but again, we'll keep you posted. So as soon as those consultations are through, we'll be having a close look at that. And we now move into 2027 and the proposed changes that are coming into place. Um, Fair Work Agency is going to be one of those. This is the agency that's going to be responsible for enforcing lots of employment rights. Interestingly, it's also going to have the power to bring tribunal claims, even if the worker or employee themselves chooses not to pursue a claim. So that could be interesting. And whilst it is possible that this might start in 2026, because the Secretary of State already has been given all the legal powers need to set it up, it's just has to appoint an advisory board and obviously their enforcement officers. So that's why we're saying 2026 because there's still a bit of work to be done and potentially 2027 depending on how fast they move. And as you can see from this slide, their powers give them the right to enforce a range of employment rights. So, from this list, I think the most impact will be around national minimum wage, holiday pay enforcement, and statutory sick pay. When I saw recovery of unpaid employment tribunal awards, the last point on that slide, I did a bit of research, and it turns out, surprisingly, that only 49% of claimants receive the full amount of the compensations that are awarded to them through the tribunal. So that's slightly less than half. 16% were paid in part, and 35% received absolutely nothing at all. 30% of those were attributable to employees point blank refusing to pay. So I guess that's why they've needed to put something in place to enforce it more effectively. Zero-hour contracts. The Employment Rights Bill already includes some complex proposals for low and zero-hour workers covering three key areas. The right for qualifying workers to be to be offered guaranteed hours based on hours worked in the relevant reference period, the right to reasonable notice of shifts and shift changes, and the right to compensation for short notice cancellations and curtailments. To extend these protections to agency workers, the government will introduce a framework through secondary legislation, and that's expected that this will mean things like, in terms of shift notification responsibility, this will fall on both the employment agency and the end hirer, with tribunals able to apportion liability between those two, and compensation for short notice cancellations to be paid by the employment agency, which of course they would then on charge to the hire under whatever agreements they have. And it is likely that the obligation to offer guaranteed hours to qualifying agency workers will rest with the end hirer. So if you use agency workers, just something to bear in mind as well. Single employment status. So this refers to the merging of the two categories of worker and employee. I mean, currently we have three employees, workers, and self employed. Employees have full employment rights, including unfair dismissal protection, redundancy pay, and sick pay. And workers, of course, have limited rights such as minimum wage and holiday pay, but no unfair dismissal protection. And self employed basically don't get any rights at all. So, whilst this was a key government commitment in the Employment Rights Manifesto from the Labor government, interestingly, it hasn't found its way into the Employment Rights Bill, meaning that if it has to be put in place, it will need a new Act of Parliament. So, if you're a betting person, it may be that it's not going to happen in this term of government. They'd have to do something quite extraordinary to put this into effect. So, that it was something that we were anticipating. It might not be something that comes into place. So, if you're a large business employing high numbers of workers, like in hospitality as an example, this change could increase your costs quite substantially. What it would do is disallow employers to exploit the ambiguity of worker status to avoid paying benefits and effectively level the playing field for anyone who works regardless of their status. And that's it. I was hoping we'd take 45 minutes, and I'm dead on time. I can't believe it. That's actually luck more than good planning, trust me. Before we go, a little bit of shameless advertising. We have our next webinar on managing redundancy to make sure you introduce fair and compliant practices, and we're putting that one on in June the 17th. And of course, we have our conference coming up in July. It's called Embracing Change. And in fact, our HR team have got three sessions in that conference where we'll be talking about the top five issues that impact on employers, as well as looking at some handy administration and audit processes that you can introduce into your businesses. If there are any questions, because we've got through that 45 minutes, I'll collate them and we'll put that in an FAQ so you all get the questions and the answers, and we'll send that out with the link to this presentation. So it just leaves me to say once again, thank you very, very much for attending. This has been a meaty subject to get through, but one that is hugely important, and I hope you've got some benefit from today. And it's given you some food for thought about what you can do to start preparing. And of course, we're here to help you if you need us. So until next time, have a great day and enjoy this glorious sunshine if you can. Thank you, everybody, and goodbye.